many of the form construction contracts that I see contain what are called arbitration provisions, which basically means if you have a dispute with your contractor as a property owner, you can't go to Superior Court, you can't go to Federal District Court, you have to go to arbitration, which means your case won't be decided by a judge or a jury, it will be decided by an arbitrator or a panel of 3 arbitrators. People ask me which is better, and my answer to them is that depends. How strong is your case? If you have a case that you think is very strong, an advantage of going to a construction industry arbitration is that the people who are deciding your case are experienced in construction. They know the glossary of terms, they know the shape of the world. You don't have to waste a lot of energy, whether that's with witnesses or expert witnesses even, to explain to the arbitrators how the world works. You can just get right to the point. On the other hand, if you don't think your case is that strong, you may be better off in Superior Court. You have to keep in mind, you don't get a jury in arbitration. You don't have a right to appeal except in very limited circumstances. So if you do well, that's great. If you don't do well, that's not so good. Another thing to keep in mind, arbitration is supposed to be streamlined. You get a little bit less discovery, so you don't usually take depositions. So it makes it a little cheaper. On the other side, though, your jury and your judge, those arbitrators expect to be paid for their time. So it actually can get quite expensive. So unfortunately, the short answer to that question is court or arbitration. It sort of depends on your case.